Okay, I have that. Anyone else?
Smith.
First name.
Chanel.
Okay. No one else?
Marquis.
Cleopatra Albury.
Okay. What's the gentleman name just now?
Marquis Kenny.
Marquis Kenny. Okay, I have you. I saw another name come up just now. Oh, I don't see that here.
Did you get me, Kimberly Russell?
Yeah, I have you. I have you.
Hi, sorry, do you have Forbes?
Brianka?
Correct.
Yeah, I have you.
Thank you.
Okay. So I so hope everybody had a wonderful and relaxing day today. I don't hear anything. That means yes.
Yes, yes, you did.
Yeah.
That's a negative.
Not at all.
Oh, Lord. Has anyone had a chance to read the module?
No, I just received today. I did not have a chance.
Okay.
Yeah, same here.
Okay.
Same.
So, according to your schedule, you do have the schedule, right?
Yes.
Yeah.
Okay.
Yes.
Right. So, tonight we're supposed to cover the concept of Bahamian land law and also understanding the conveyancing process. So how many of you work now in lending? Any of you work in lending?
I do.
Yes, I do. I do.
Okay. So I don't need to go on that one in too much detail. We can start it, but if you actually go through the process as a daily part of your job, it's really just noting what you do for those who've never done it before. And as you know, when you look at documentation for conveyancing, if you're not actually doing it, even though it's written, it's very hard for you to conceptualize that process. Because that's what process means. You're going through each of the steps as a part of your day-to-day routine. So it's 6:04, 6:05. You all want me to wait a couple minutes or you want to start? Because we're missing almost half the class.
And they're confirmed?
Supposed to be. Someone named Young just came in, said good afternoon. Come on, it's a consensus class supposed to begin at 6. If you are ready, I will begin.
I'm ready.
I'm ready.
Ready?
Please begin.
Ready. Same here.
Oh, Lord, eager beavers. All right. So if I go too fast, let me know. If there's something you don't understand, ask me. All right, so let's talk about Bahamian land law. And in your mind, I want you to just forget all of the definitions that you know and listen carefully to how we define land in the Bahamas and in the English legal system. So let's look at the word property. Property means ownership. And when you speak about property, the law of property is a law of ownership, and with ownership comes rights. So really, when you talk about property, you're talking about rights to land. So property really means that which is owned. We understand that concept?
Yes.
Okay. So let's look at what ownership means. Ownership means the right of a person to enjoy a property as fully as the law permits them to. Or they could assert that they own a property, or that it is a right against anyone else who asserts that they own the property. So in law, you say ownership has 3 rights. A right of using, which means exclusivity. Second one is profiting, because when you have the land, you profit from whatever is on the land. And third, you can alienate yourself from the land, which means that the land either diminishes, or you destroy it, or you transfer it to someone else. So with regard to ownership, you could lose possession of it, but you do not lose the title of it. So losing property that one merely possesses means that you lose physical control of the property and any right to exclude persons from controlling it. So how many of you own a piece of land or your own home?
Sorry, can you repeat that last statement, please? My internet.
Oh, yeah, because it's dropping.
Mm-hmm.
With ownership, you can lose possession of it, but you do not lose the title of it.
Explain
So-
that in terms.
Losing property that you merely possess means that you lose the physical control of the property and any right to exclude any person from controlling it. That's what losing property
So
means.
is that like for example, squatters, like people who squat? The
Yes, you can
title-
refer to them. Yes.
Okay.
How is it that you don't lose the title, although you lose the control of it?
Because when you're in possession, then you're in control.
So I can lose control of a piece of land, but still hold the title to the land.
Yes. Okay, when we go further, then you'll understand how
Okay,
land is treated in law.
okay.
Okay, so there are other rights when it comes to land. And ownership of a thing can be regarded as a right in or to that thing. So property has rights, and property rights include easements and profits. You heard those words before?
Yeah,
Okay, so easement is what?
it's a right to a piece of land.
Okay, and what is profit?
You don't own the land, but you can benefit from what the land has. Like you have equitable use of the land.
You won't use the word equitable use. You just have use.
What about rental?
Well, I don't own the
Mm,
land, but I can farm it, and I can I own the crops that I grow, and I can sell them, and I can.
yeah, or you could take your animals on the land and let your animals feed on the land.
Right.
Mm-hmm. Or say if they have like a pond, you can go fishing in the pond. Or, sometimes when people
That
do,
would be
go ahead.
of the profiting aspect.
That's
of
profiting,
ownership.
right? Or
Okay.
you could go on someone's land and you could hunt. That's profiting. So another type of property right is restrictive covenants. I know you heard about those before. And it's normally in the deed. And it more or less tells the land, whoever is the successor landowners, what they cannot do. And so it passes, as the land passes from one owner to another owner, That restrictive covenant goes with the land.
Okay.
So title. Title is the true nature of ownership. It's so let me set up for this to you. Property concentrates on possession. And when you have a dispute with property, it really comes down to who has the better right to possession and who had the earliest right to possession. So when you say possession, you're talking about exclusive use and control of an item or property, but with no rights or title to the property. So it's just like when someone moves into a house, that doesn't mean that they have title to that house. And it doesn't mean that they have rights to that house, but they have exclusive use and control over the item while they're in it. Now, possession can also be evidence of ownership. And that's when it comes to whether they could exclude others from being on that piece of property. So whenever someone wants to purchase a property, there is in the next chapter the steps that you go through in order to purchase property. And the vendor has to prove that he has a good title to that property. So let's go to what do we look at? Things capable of ownership. We know that land is capable of ownership. But there are physical things that you can also own, such as clothes, tools, food, books, cattle, goats, horses. These are called chattel. Normally when someone gets a car loan, what does the document say when you register it?
Title, deed, or something like that?
Chattel.
Say chattel. It says chattel. Okay. So over time, the law recognizes that there are other types of ownership or things that are capable of ownership, and they've been listed here. Debts, patents, copyright, shares, computer software, computer program, and the list goes on and on and on. As things become more in the realm of ownership, then they classify it under the relevant category. So when you talk about property in law, there are two types: real property and personal property. Real property refers to what we call freehold interest in land. And personal property is tangible and intangible. That are properties that are not considered freehold. So, for example, personal property may comprise of leasehold interests in land. You know what leasehold means? Okay, so leasehold means that you own a piece of property, fee simple, absolute in possession, and then you decide that you want to lease it, which means you're going to let it out to someone. So they want to be on your land for 20 years. So you draw up a leasing contract where they can stay on your land for 20 years. That person who leases your land, they can in turn lease it to someone else. But they cannot lease it for a term greater than what they have. So if their lease is for 20 years and they stayed on the land for like 5 years, they have not done anything with it, or whatever they did was not successful, they can now lease it to someone else. But they cannot lease it for 20 years. They can only lease it for the balance remaining in their lease agreement. That's a lease.
And that's subleasing, right? When they do that, subletting, how do they? What is
No,
that?
that's not letting. That's lease.
Mm.
When that person who leases it to someone else,
Mhm.
that person then takes possession for the period that they have it in.
And that's
So that
legal
would be
to
like
lease
a
when you're leasing.
rental agreement with the lease. Yeah.
Yeah.
So if I sign a lease when, like, let's say I sign a 1-year lease to rent an apartment or to lease an apartment.
Mm-hmm.
If I decide after 2 months I don't want to occupy that apartment, I can lease my lease.
You know, depends what the contract says.
What the contract says.
Yeah.
Everything depends on the contract. That's why there are many clauses. You have to read them. The clause may say that you have to stay for a period of 6 months before you can turn. Or the contract can say that if you intend to terminate any time before the 1 year, there is a penalty. It may say you have to pay them up to 3 months rent in advance as a penalty. So there are different ways you can word it. So personal property is a leasehold interest in land, and chattels personal, which is like cars, boats, and jewelry and furniture. And chattels personal is further broken down into 2 groups: choices in action and choices in possession. So choices in possession consists of property which do not physically exist and cannot be possessed. So a choice in action is like a copyright, a patent, a check, or goodwill. And normally a bank would give a legal or equitable charge over choices in action for loans, such as a life insurance or shares or guarantees or debentures. Choices in possession, which is the second category of choices, they are personal property with a physical existence: books, clothes, computers. So let's go over the classification of property again. Property is divided into real property and personal property. Real interest in land. Personal property can be divided into tangible and intangible. Tangible is leasehold interest. Intangible is chattel personal. And chattel personal is further divided into choices in action and choices in possession. Getting more confused? Or we good?
Ms. Archer, are you referencing a particular page, or are you reading, I guess, from notes that you have?
No, let me see. Let me
Page
go
12.
to it. Okay, you have it in front of you. Yeah.
12?
Yeah, from
Okay.
page 12.
Thank you. Okay, I see.
You got it?
Yes.
So the best way to do classification of property for you to study for your exam is draw a diagram. So when we talk about land, land can be divided into real property, which is the building and the structure, and the rights over land. You understand what I mean? So all of this talk about when people say in the old days, they'll say they struck oil on the land. So land is the real property, that's the building on it, and then the rights over the land. So that could be mining rights, rights of way, easements. Those are rights over land. When you speak about land, it doesn't speak about fixtures. Fixtures are things which are attached to the building. So remember that when you ever speak about land, Land is about the building and the structure and any rights that go with the land. It does not include fixtures. So land, realty, or real property is distinguished from personality or personal property. So generally speaking, land law relates to right over land rather than the land itself. And you'll see this when we go to this next section now. So when you go and you purchase a piece of land, which that piece of paper that you hold in your hand, that conveyance, or if someone dies and they leave you a piece of property and you have the assent from the lawyer. In land law, you don't actually own that actual ground you're standing on. You own an interest in it. So when someone comes for mortgage, as you know, they have to own that property. And they own that property in what we call fee simple absolute in possession. We'll go to what that means in a minute. So once they own that outright, when they mortgage that property, they're going to mortgage an interest in that land. Who really owns the land where your house is built?
The crown? Is it the crown?
It's the crown. The crown owns it. So when you go to the bank, you can only give one of your interests or both of your interests. Legal interest and your equitable interest. Or you say there are two rights over land. A legal right and equitable right. Anyone think they could explain the difference between the two?
Wait, Miss Asha, sorry, before you move on, you said that you don't actually own the land, you own an interest in the land. So
Yes.
does that technically mean that at any point, even though you own an interest in the land, the government can kick you off of your land since they own the land?
They won't kick you
itself?
off. They won't kick you off. They will acquire it from you.
So at any point, the government can just acquire your land.
Yes.
So would that mean that nobody owns land technically but the government? Everybody just owns the interest, equitable interest in their property to live on it, to use it, to mortgage it. But everybody's land is basically owned by the government.
Owned by the crown. Don't say
By the
government. Crown.
That's only for common law jurisdictions.
I'll have to check civil. I can
Because
check for you.
I'm just thinking about, let's say, for instance, when you have a situation where a government owns a piece of property in another country and they make it an embassy property, right? And they would consider that, let's say, like the U.S. embassy here, they would consider that U.S. soil. So, but it's situated in the Bahamas.
That
right?
falls under different law, though. That goes under the Diplomatic and Immunities Privilege Act.
Okay, something separate. So you are saying that as a citizen or as a company or any other non-diplomatic body, you don't own the land. The crown owns the land. We just own the interest.
Interest in the land.
Okay.
Yeah. So the part where you say like the U.S. embassy, that is their territory, that falls under that diplomatic immunity legislation. But that does not mean that they physically own that land, so that when the embassy moves, they lift that land. That don't work like that. Just by them being an embassy, that legislation takes over. It says that when you walk through that security pipe, when that goes up, you've entered onto American soil. That's what that means. That doesn't mean that they own that land. Because you could take that land and put something else there.
Right. Right.
Because now they're moving to a new premises.
Right.
And so if they no longer want that one,
Mm-hmm.
they can say the building is up for sale.
Yeah.
And then they move their premises elsewhere. Or they could decide to keep it for whatever reason.
It's very confusing, I guess. I guess everybody always thought that when you own a piece of property, it's my piece of property.
That's
Yes.
what I'm thinking too.
You know?
No, it's not. No.
I know government has crown land, and with crown land.
Hello?
You don't
Tell her her
sell,
thing is
but the
slurring.
government uses crown
Oh, okay.
land for their own personal, I guess, buildings. But to say that you bought a property, you got the conveyance for it, and now it's still. Hello.
We could hear you,
Hello?
but you were slurring just now.
Hello.
Hello.
Yes, ma'am. No, I was saying that I am kind of confused with that as well. I thought once you purchase a property, you
Mhm.
receive your conveyance, that would be considered your property, whereas crown land, government doesn't sell crown land because that is used for government and the buildings to lease for farming and for their own ministries or whatever buildings they would want to build.
No. No. When you get that piece of paper that you call your property, that paper conveys your interest in the land.
So, Ms. Archer, I guess if that's the case, what circumstances would have to occur for the government to acquire land and then it not be your land anymore?
I think they
The
do that
government-
sometimes when they're making roads, like how they cut up the people on Eastern Road property
Right.
to build a road.
So
They pretty much-
they'll actually put a notice in the paper and they will give you the map as to where they're going to build their road or widen the road. And all the landers that affected in that area, you will actually get a notice saying that the government needs to acquire your land to do whatever it wants to do, and they will give you fair market value.
Okay, okay, that makes sense. Okay, thank you.
Mhm. Okay, so when you own a piece of land and you own it straight out, you don't owe anybody any money for the land, and you have your conveyance in your hand. No one else is making a claim to that piece of property. Then you have both legal and equitable interests in that land. You have both. A legal interest can be divided into two subsets: a legal estate and then the legal interest itself. And the legal estate means that you can have a freehold or you can have a lease in a state. A freehold means that there's no obligation on no one. No one has a superior title to that land but you. No one can come and say that they own that land other than you at that point in time. And so we say you own the property, fee simple, absolute, in possession. Fee simple means in the state and land, which can endure indefinitely and pass either by sale or gift. Because if you don't own the land in fee simple, you cannot pass it on as a gift, nor can you sell it. Absolute means that it is unconditional. There's no restrictions on that piece of land. And in possession means that you either actually in possession of it or you have the right to receive rent from it, or profits, as we say. The leasehold estate means the tenant derives the estate from a superior tenant. That's the one I explained to you already. So you could have a freehold estate with a leasehold estate. A freehold who then leases the property to someone else. So the person who grants the lease is the landlord or the lessor, and the person who receives the lease is the tenant or the leasee. So even though you have your property on lease, the freeholder, the person with fee simple absolute in possession, is still the person with the legal interest. Whenever you speak about leasehold, they refer to that in land law and property law as term of years absolute, which is what I explained to you earlier. If you give a lease to someone, you grant a lease for 20 years, they cannot in turn lease it to someone else for a period greater than theirs. That's why it's called terms of years absolute. So an interest in land is what you call a right to a claim against the land of any other person that have a lesser claim than yours. An interest in land can be legal or equitable. A legal interest is a right over land which is given to a non-owner, but is still valid against everyone, and gives the non-owner a right which is less than the actual possession, as in the legal estate. So we're talking about when you have a right of way over a neighbor's land, and where you have to walk through that neighbor's yard to get to your house, you have a legal interest. So that'll be something where what I have for an example, an easement, or a charge by way of legal mortgage, a rent charge, or a charge imposed on land by law. So your conveyance gives you have a legal right, and then you have equitable rights. Your legal rights are divided into your legal estate and your legal interest. Your legal estate is divided into freehold and leasehold. And your legal interest is where you have rights over land, such as easements. Your equitable rights are valid against anyone who has notice of such rights, actual or constructive. So if someone purchases a piece of property without no notice that that property was owned by someone else, no way of knowing that that was owned by someone else, it can acquire the property free. And you'll see that sometimes. Equitable interest is, for example, equity of redemption. And that's the right of a mortgagor to redeem the mortgage property upon payment of the outstanding principal and interest. Or you could have an equitable charge. Interest in land taken as security for a loan without creating a formal legal charge. Or you could have a restrictive covenant. That's an agreement where one person promises to restrict the use of their land for the benefit of another person's adjoining property. I don't know if those of you who do lending, if you look at sometimes at some of the conveyances, you'll see a restrictive covenant that this property is not to be used for the selling of liquor, or this property is not to be used for selling cigarettes. People put those kind of restrictive covenants in their property. So in law, you could have legal and equitable ownership of a legal estate and land. Legal ownership gives legal title to the estate, and equitable, or what we call beneficial interest, gives the right to benefit from the estate. And you see this normally when you look at trust. When someone establishes a trust and they give their property, what happens?
I think in a trust, the trust owns the property, but it's for the use of the beneficiaries of the trust. So they are the equitable ownership of it. But legally
Right.
owns it.
The trust, so the trustee has legal interest and the beneficiaries have equitable interest. So in that example, the equitable and the legal are separate. The legal owner can always dispose of their legal interest, and the equitable owner can also dispose of their equitable interest. So the legal owner could actually create a legal or equitable mortgage, but the equitable owner can only create an equitable mortgage over the land. So again, go ahead.
Sorry. May I ask a question? Okay, so I have a question. My grandfather left me with some property, right?
Mm-hmm.
And the property, I have the conveyance for the property, where he bought it from some people. However, these people are still on the property and they're saying that he never sold the property. He never actually bought the property from the previous owner. But I have an actual conveyance where the property that the people are on was sold to someone and my grandfather bought it from that person. And they're saying that, oh, no, who actually owns the property if that's the case. And I have both conveyances. How do I actually, something like that?
What is their proof that they own the property?
I don't know that they have any. I know that. Okay, it was, what do you call it? Like squatting rights. At some point, these people squatted this property, right? I had somebody do a title investigation on it. So they confirmed that the property was quieted by these people. They sold it to someone who then sold it to my grandfather. And so I have both conveyances, the one where they sold it to the gentleman and the one where my grandfather purchased it from the gentleman. However, they never moved off of the property.
So how did the person who they sold it to, did he actually buy it?
Yeah, I have both conveyances.
That's impossible though. If think about it, if you quieted a piece of land, right?
Right.
You quieted it. When you quiet it, that actually goes in the papers.
Right.
And then the court grants you that piece of property.
Right. They were granted. Right. They were granted the piece of property.
Okay. And so when they sold it to whomever,
right?
Say Mr. Joe.
Right.
Why did Mr. Joe let them remain on the land?
They were relatives. They were relatives. So like Mr. Joe was their cousin or whatever. Let's say they were a cousin. So Mr. Joe was the cousin and Mr. Albury was the person who bought it from Mr. Joe. But Mr. Albury, he lives in Exuma. So of course, he ain't really going and doing no checking or whatever because this is on another island where he brought this property. So he wasn't going, so he's figuring now when he dies, he's just, putting this stuff and it's in his will. So in his will, this property comes up and when we go to look.
Hold on. Is that property commonage?
No, it's not. No, ma'am, it isn't. What do you mean? Like common law? Like not common law. What do you call that?
Property that's gifted to them from the slave owners.
No, ma'am. No, it's not. I forget. We call it something else in Exuma, but no, no, ma'am. That's not it.
But some of the property in Exuma is commonage.
Yes, ma'am. Exactly. But no, it's not. It wasn't anything like that. It was actually property that he actually paid money for. Like,
but it's not necessary. But it's not his just because he paid. Is whether at the time that he paid, he had good title to it.
Okay.
Whether the person who sold it to him had the right to sell it.
How do you find out if they This was after the quieting portion happened, though. Like the quieting portion happened, they got all the rights to the property, and then the cousin sold his part to my grandfather. So how do you?
When you say sold his part, what do you mean?
Like, I guess he had 10 acres or whatever that he wanted to sell, and he sold that 10 acres. Like, let's say it was 20 acres in total, and 10 acres was one cousin's, and 10 acres was another cousin's. And so the 10 acres, which was Joe's, Joe sold to Mr. Aubrey.
Okay, let's go to co-ownership.
Okay.
Okay, so in co-ownership, when you have property, there are two types of ownership. Joint tenancy and tenancy in common.
Mm-hmm.
Right? So joint tenancy means that where there's two or more person owning the whole interest in the land,
Okay.
they don't have separate shares.
Okay.
That prohibits any one of them having exclusive possession of the whole or any part.
Okay.
So the first question you have to look at is when they quieted the title to that land.
Mhm.
What type of ownership did they have?
Okay. And how do you find that out?
That's written in the document.
Okay.
When they quieted the land, that would be written in it. If it is joint tenancy, right?
Mhm.
Joint tenancy is legally is 4 tenants,
Okay.
right? When one dies, the next 3 own all of it.
Gotcha. Okay.
There's no separation.
Okay.
Now, a joint tenant, they could sell or mortgage their equitable rights in it, but not the legal. So that's what they need to look at. What rights did they have? Whoever that family member had, what rights did he have when he sold it? Because remember, I tell you, when you have that conveyance in your hand, that doesn't mean you own that 100 by 100 from the top to the bottom and all the 4 squares.
Okay.
You only have an interest.
Okay. So how do you figure out what your interest is in it?
It's the wording of the document.
Okay.
So you'll have to read the quieting title to see
Right.
what type of ownership
They had.
they had when they quieted the land.
Okay.
And then look to see the person who sold it, who they sold it to, did he have that right to purchase that piece of land from there?
Okay.
And then from there, whether he had the right to sell it. When I say the right, did he have both legal and equitable interest in that land? Because the piece of paper that you're holding, if you want to be able to use that piece of paper now, you must have both legal and equitable interests.
Okay.
If you want to say you have fee simple absolute in possession, this means that you can take that piece of property and go to the bank and use it as collateral. Otherwise, you may only have just an equitable interest.
So how do I, what can you do with your equitable interest? That if someone's on it,
You can use the equitable interest in a mortgage.
but people are on it.
Because you have to start from the beginning.
Oh, so I have to go all the way back to
Yes,
when
you do.
you quieted it. Gotcha.
Mm-hmm.
I see what you're saying.
Mm-hmm.
Okay.
Because the family member they sold it to, they may not have had the right to do that.
Okay.
And then when he sold it, he may not have been able to sell both legal and equitable interest in that land.
Okay. Got you.
If it's the other way around, that yes, he did have that right. Yes, your father did purchase it. Then the next question is, they've been squatting on it for how long?
From 1974.
Well then, I don't know how you can move them off. You have to go to court.
They didn't build anything, but they use it like as a parking area. They have like some trucks and different stuff on it.
And so from 1970, whatever it is, until now, you're the first person who's come to tell them that you own land.
Well, actually, no, I think my grandfather came before me, before he died, because he just died like 8 years ago. So
Did he stop them?
well, he tried, but you know, I don't know
You
exactly.
didn't put a chain around it? You didn't do anything like that?
It's 10 acres, so I don't know exactly what happened. And then my grandmother isn't in her right state of mind to say, you know, the only thing she did was give me some documents, and I found these documents in it along with, I guess, everything else that the lawyer had. So I wasn't really sure what to do with it.
Well, you have to start from the beginning and see whether or not the family member had the right. Because if
To actually sell it.
right,
Gotcha.
because if we own as a family 100 acres and I decide that I'm selling my 10, why would the rest of the family members still be on it?
I got what you're saying.
Yeah. So first you have to look at the issue and make it practical. If you know that your cousin Joe sold that piece of land, would you still be sitting on it? Of course not. It has a new owner.
Well, I was thinking maybe they were just sitting on it because they figured no one else was, I don't know that no one else was coming to do anything with it because it's like 10 acres, and I kind of figured it was off of a lot of acreage. So I just kind of figured, you know, they just say, oh, this little piece over here, ain't nobody doing with it, so let me just, you know.
So you trying to tell me that they quieted 100 acres? That don't sound right.
They quieted quite a bit more than 100.
How is that possible?
Miss
You know there's
Archer,
100 acres?
Mr. Bahamas?
Mm.
Archer, afterwards I'm gonna read to you the conveyance that I have after class, and then you can tell me.
You need the conveyance that they got when they quieted the land.
So how do I get that? Where do I get that from?
You have to do a title search, eh?
Title search, yeah.
Okay.
Title search, and then go to the courts and pull the document.
Okay.
Mm-hmm.
Okay.
Okay.
All right. Thank you.
Mm-hmm. So the next co-ownership is tenancy in common. And that's where there's two or more persons owning the land jointly. And they can be split either equally or undivided. And there's no right of survivorship. So when one person dies, whoever's the personal representative of that person, they would then distribute the land to whomever it's supposed to go to. So there's two, joint tenancy and tenancy in common. So that's another thing you have to look for in the document. So the Bahamas is what you call unregistered land system. Anyone knows what the registered system is like? You can take a guess.
Organized?
I guess the US, they have a registered land system, or don't they? It's more organized. You could go and pull everything and it doesn't take as long as it does in our jurisdiction.
No, nothing takes as long. In countries, all you do is put in the land or put in the person's name, and whatever property they own is right there in a matter of minutes. But in the Bahamas, we have unregistered land. And so you have what we call, if you're buying a piece of land, you should have an abstract of title. And that goes way back as far as 30 years as to who owned the land. So abstracts of title, you could get conveyances, the mortgages, the release of mortgages. You have to do your searches, assignments, and then you have to list all of your documents. So it sounds to me, without being discouraged, it sounds to me that whatever family member this was, he figured he could get a few quick bucks. And he sold 10 acres. Now, whether legally he could have done that is a different question.
Why is it in only 30 years? Why is that the statute for I guess, title searches and, you know, doing those checks.
That's what the law says, 30 years. That's where you stop. That's where you stop. 30 years. But in the instance with the example, which you're giving now, with regards to it being quieted, you don't go behind that. Because in order to quiet it, they would have gone through all of those searches.
So I don't go past the quieted portion?
No,
I guess? Okay, gotcha. Okay.
Because the
Ms.
courts would
Archer,
have gone
can
through
you
all.
define what is quieting? I've heard that term several times.
This is when someone has been sitting on a piece of land and they now decide to go to the court and say, guess what? Nobody has come to clean this land. We've been sitting on it and we would like to own it. And then they publish it in the paper. I don't know if you ever noticed it before. It says Quieting Titles Act. You never noticed it in the papers?
No, I've never seen that before.
No, don't say that. always in the papers. People are let me tell you, you could be sitting on your piece of property and someone could be quieting it, you know.
Wow.
When you look, you see somebody come, and you would have passed the window. That's how it's done.
Okay.
That's how people quiet land.
That's very tricky because you may not even know, let's just say, in the case of Mr. Albury, right?
Uh-huh.
He had the properties that he intended to bequeath to his issue, all right? He want to pass on to grandchildren. And you would not know that in most cases. They don't make these things apparent while they're living. You only find out after they pass away, and you find some will or some kind of document, okay? So all the time he wasn't checking up on it. All the time you didn't even know you had an interest in it. Someone could be quieting it, and you don't know. You
No.
see what I'm saying?
No, you don't know. Because guess what? You could have a family member that owns a piece of property. You never saw the conveyance. No one ever spoke about it. Someone could come and quiet it.
What's the protection against
The quieting of when you quiet a title, you put it in the newspaper. Newspaper means it's public notice to the whole world.
How long is it in the paper for? Like, is it a substantial period?
I don't know, but those substantial.
What
See right
kind of,
now.
sorry, where in the newspaper do you publish it? Like anywhere?
It's in the paper, anywhere.
Okay.
Long
Because
as
I
it's
know
in the paper.
I've seen things in the newspaper where people want to change their name or
All of that. The
sort of
quieting
things.
is, the quieting is
So
in there
it's the
too.
same, so it's the same difference, I guess.
Yeah.
Okay,
It's a notice to the world.
Okay. Now, not going back so far, right? I see you have in here legal interest in terms of an easement. So so if you have a piece of property, right?
Right.
And there's another piece of property next door to you, and there is a 30-foot easement between the properties. How do you have whose road is it? How do you know whose road it belongs to?
The property itself, from whenever the property was conveyed, would say who owns the land itself.
Okay.
And then the other property would say that they have an easement over it.
Okay.
It's actually written in the conveyance.
Right. So somebody can't come and say, "Oh well, this is my property, and so now I put
No.
house." Okay.
That's why I say you have to read. When you have to read it to see what actually goes with the land.
Okay.
But that makes a big difference.
Okay.
I'm trying to say, okay, that's a lot.
Sorry.
Go ahead.
Sorry. Another question. Doesn't have anything to do with how long does it take to quiet a piece of property?
Oh, there's a certain number of years. Can't remember.
Supposed to be 20.
20 don't ring a bell.
Longer than 20?
The number's not coming to me. I can't remember.
Okay.
I can look it up for you. I can tell you when we
Okay.
have the next class.
Okay, no problem.
How long it is to quiet. Okay, so the next little piece about unregistered land it speaks about the process, which we're about to start in the next chapter. The process to actually transacting a purchase of a piece of land and making sure that you have root title and make sure that your title is clear. So when we speak about the modern law of land law, there are certain legislations that you need to be familiar with, and they're all listed there. Isn't that wonderful? 2, 4, 6, 8. I think that is wonderful. Y'all could be reading law until I don't know when. Okay, hold on. Let me see if I can find this for you.
Where do you actually find this information? Is this in here or do we?
But the
this
legislation?
ourselves? Yeah.
The legislation? No, we have to go to laws of the Bahamas. .gov.bs.
Thank you, Ms. Archer. I appreciate this light piece of reading.
Of course, it's fun.
Repeat the website for me, please.
laws.bahamas.gov.bs. And all these wonderful pieces of legislation and all of their many amendments are right there. So let's go and talk about understanding the conveyancing process. So instead of me talking, those who are in lending, we can go around and let's see what we know. What's the first step when you want to purchase a piece of property? Anybody?
Title search. Title search.
How are you getting the title search first? And you have to find someone to buy it from?
Find a piece of property you want.
So you're a realtor?
You need your purchase agreement and your intent.
You know your budget, right?
You need a budget first.
Yeah. You know.
Before you start anything, you need a budget. You need a budget to see whether or not whatever area it is that you want to live in, whether you can afford that area, or you may have to decide to go someplace else. So let's just say you go to a realtor and you see a piece of property you like. What's the next step?
Get pre-qualified to see if you can accommodate the payments for that particular property.
Yes. And if you can, what do you do next?
If you what?
If you can, let's say you can make the payments. What's the next step?
Put in a bid.
I would want to know what I can do on that property. Why am I buying the property?
No, let's take it another way. We don't want one of those houses that are up for sale. Let's say we get a piece of land, just the land by itself first. You saw a piece of land and you want to buy it. Or someone told you that Mr. Joe is selling a piece of land, 200 by 100 by the ocean. He's selling it for $250,000.
Not available in the Bahamas, Vajaja.
I just come up with an easy figure.
2.5 million. Go ahead.
Okay, 2.5 million. All right. So you must be a millionaire. So what's the next step you're going to do? Make him an offer, right?
Yep.
Okay, make him an offer. So he agrees that, all right, he'll take 2.2 million. What's the next step?
You need to get a purchase agreement?
Agreement for sale.
Yeah.
I thought you go to a lawyer to get a title search.
No,
that
Comes
after.
a little down.
That's after. That's after.
Okay.
No, you don't do it at the beginning. No, you get agreement for sale.
Okay.
And in the agreement for sale, what's included in that?
The
same
purchase
point that she's
price,
making. The purchase price, the deposit,
the deposit,
completion date
mm-hmm.
for the sale, and the point that she was making just now, that the person who's selling it to you could prove he has good and marketable title. That's the key to this agreement for sale. Someone cannot sell something to you if they don't have good and marketable title. And then in that agreement for sale is the consequences to the vendor, the person who's selling to you, selling it to you if they cannot prove that they have good title. On the flip side of it, there's a penalty for you if you cannot provide the financing to complete the deal. So everybody has a weight on them, the vendor and the purchaser. All right, so we sign a contract. I say I'm gonna pay 2.2 million for this piece of property. So we sign it, and I give him 10%. What do
Go to the bank.
And what the bank could do?
They would do an application, giving you all the conditions and guidelines in terms of moving forward with the financing, if you are qualified for it. And then you will have to supply them with the necessary documentation, such as job letter, KYC, financials, stuff like that.
Okay, so let's put it on the opposite side now. That's what the bank is going to do. We are purchasing this piece of property. More than just getting what the bank requirements are, we need to find out whether or not this person has good title to sell this piece of property.
So your attorney will do the investigation now.
They do a title search, yeah.
So first thing is, the vendor has to deduce his title before the exchange of the contracts. So we've already agreed we're going to sell the purchase. I give my 10%. We write up our contract. The vendor now needs to say, guess what? Here's an abstract of the title. I own this property. Fee simple, absolute in possession. So now you need, your lawyer now, the purchaser, now need to investigate this title. If we had a registered system, what would we have to do?
Just key it in the system.
Just key it in. Okay, so now you're going to spend some money to the lawyer to investigate the title.
Right.
So how does that work now? What is he going to be looking for?
Yes, you have to go to the registrar.
Any defects in the title?
Yes. So the first thing he's gonna look for is to make sure, first, to see if there's any judgment against the owner of the property. That's the first thing that they do. Are there any cases out there with this vendor's name on it? That's the first thing.
What do you mean by cases?
Why does he
No, legal matters. Any legal matters that have your name on it, the purchaser's attorney is going to list those matters and say, I did a check of the cost list at the court and found the below cases in your name.
Why does he need to know that information?
Because guess what? If you have cases against you and that is one of your assets, these people could become creditors.
Okay.
Okay.
But that includes things like, let's say, if he's going through a divorce, right? And
yes.
The assets, because at the end of the day, that property may be trying to sell, maybe
yes.
It was a part of his settlement. Let's just say, right, and now he can't sell it.
Or he could be so may need some money. Who knows? Someone else could have put him in court. But they go through all of that. So what's the next step?
Wait.
Then he goes back and checks the title, back to 30 years. Or to a period extending further back than a grant or lease by the government.
What about real property tax?
That's the next step. That's the third one.
Okay.
Third one is real property tax.
Sorry. Oh, can you hear me?
Mm-hmm.
Also, is the maximum search period is 30 years?
Or for a period extending further back. Okay, let me tell you what you do. You do a search. So say this, the first search say, property was bought from Smith. Smith brought it from Pratt. Pratt brought it from William. William brought it from Ambristas. You have to keep going back until you hit that there was a grant by the Crown or lease by the Crown.
Mm-hmm.
Because you got to get to the point where you have good title. That's what they mean by when they say the word root.
Okay, another question, Ms. Archer. So I'm just a regular layman, right? So how do you get all of this? Where do you go to find this information?
Then you have to go to the title search company.
Oh, gotcha.
It's a company in the Bahamas that does that for you. You'll have
Okay.
to pay. There's not a press of button. have to
Ah,
pay.
okay. Oh, okay. Gotcha. I figured you had to pay someone.
Oh, no. When you read this whole section.
Can you do it yourself?
Would not be wise.
No.
Okay.
No.
Just
No.
thought I'd ask. Okay.
Won't be wise.
Okay.
Okay, so then you need to look to see if there's any outstanding real property tax, any utility bills. You look for anything that's outstanding related to that property. Then the purchaser's attorney, the vendor, questions. After they finish the investigation, they can ask questions. And sometimes the purchaser's attorney will say, well, leave it open in case I have more questions. So there's normally a specified time for all of this investigation in the contract. And so it has to be done within that period. And then, of course, there are other questions that can be raised afterwards. You can ask about subdivision approvals. Were there any property tax assessments? Are there any rights of way, any restrictive covenants, any easements? All those questions have to be asked.
I have a question.
Go ahead.
Like, okay, so we know the Bahamas with all these different rumors, people keeping property, quieting property, or like you said, not having even the outright, rights to sell a piece of property, right?
Yes.
And based on the steps that you're given, the title search, which is one of the more, in our mind, is a pressing matter. I feel like that's something that we would have thought would have been done sooner in the process, as opposed to then, having to go to your lawyer, your real estate person, spending money, let's say, with them, only to get to, let's say, the 7th, 8th step of doing the title search, and you can't buy it. You see what I'm saying? You can't.
Mm-hmm.
Is not process done sooner? Because I'd rather go to the title search people, pay them the money now, and let them tell me that I can buy it, it's eligible to be bought, and then go through the drafting of, the interest of acquiring, and, the real estate person, the bank.
I get your point. But maybe an astute person would do that, but most people don't.
I think most persons use a realtor.
Yes, use a realtor. Yeah, so the realtor knows that by him, it's either something that he knows, good title as far as he knows, or it's something that the bank gave him to sell that he knows has good title because the bank would have done it before the mortgage. So he has that comfort. But like say, let's just say you were purchasing a house on a piece of property, not going through a bank. And Mr. Smith say, okay, he's selling this property, he's getting old in age. Like you said, if I were you, I'd go and see whether or not he really does have the title to sell it to me. Because you don't have any cushions around you. You don't have no realtor who's representing a bank.
Mm-hmm.
So you may want to do your homework before you commit to that.
Okay. So you could do it, just normally there are safeguards to say that when you do it through a bank or a realtor, typically everything's okay. But
yeah,
you do not much early on.
Mm-hmm.
Oh, okay.
Right.
Not a problem. Sorry, go ahead.
Okay. Someone else was making a point. No? Okay. So the purchaser's attorney then prepare a report on opinion on the title, saying the property is good. And then they draft the conveyance. And then the conveyance is the normal thing that would include the names and the title and all those kind of stuff. So if we go back to the example that the young lady gave us, It's very difficult when you have a piece of property. Let me give you an example. My grandmother died. She always spoke about the property that we owned on the family island. And she said that there was a mix-up in the name on the conveyance. And we didn't realize it until after we sold the house that she lived in, that she actually had the conveyance all of these years. And all it simply had to do was for her to prove that the name on the property was not the name of her husband based on the second initial. Her husband and her father-in-law had the same name except for the second initial. And all she had to do is go and take the receipts to prove that he was the one who paid for the property, and she never did it. So the receipts and the conveyance, which is in the name of her father-in-law, was still in the house. And it is too late to get it. Because my grandfather would have died almost 75 years ago.
Ms. Archer, so an affidavit wouldn't clear up something like that? I know that sometimes like
They're
when-
all dead.
Oh, wow.
All dead.
Okay.
Yeah. Yeah, all dead.
Okay. Affidavits wouldn't help them then.
No, won't help. No. The land is gone. There's nothing you could do. Yep. So on completion, what happens? The conveyance is finalized, and what happened? Exchange of monies. And then it's time to start paying all of those bills. So we'll come back to that later. Purchase of property by non-Bahamians. So if I'm a non-Bahamian and I want to purchase property, what legislation that falls under?
International Persons Land Holding Act.
That's right. And what does that require them to do?
Oh, sorry, repeat that for me, please. If you were...
If you are a foreigner and you wish to purchase property, you purchase that under the International Persons Land Holding Act.
Okay.
So what's the process?
They must register their purchase with the Bahamas Investment Authority.
And then what else?
Then they must get a permit from the investment board prior to their purchase.
Now,
But they don't have to
That is what
establish residency at any point in time, no?
Hold on now. Go ahead, say it again. What was the question?
I was asking if they would have to establish residency prior to even being approved.
No, after they purchase.
After.
Okay.
So permanent residents are required to register their purchase of real property in the Bahamas, whether vacant or non-vacant. But they don't need a permit.
Right.
A certificate of registration is not only required for vacant and non-vacant land, but also for condominiums or property under 2 acres that will be used as the owner-occupied property. Non-Bahamian lenders that acquire security on properties in the Bahamas are required to obtain exchange control approval and a permit from the Bahamas Investment Board. Let us look at stamp duty. What's the stamp duty requirement in the Bahamas?
Is it 2%?
10%.
Oh.
I think stamp duty is 10%.
It's 10%.
Oh.
It is 10A.
Wow.
The value up to, but hold on, let me see. They changed the law and they said in the last amendment that stamp duty and VAT is the same. So they got rid of stamp duty and they put it all under VAT.
No, they went back to the Stamp Amendment Act of 2016.
Hold on, I gotta get my stamp amendment because I was looking at this night before last and I said, what confusion is this that they're writing?
It went back to 10%.
So is it 10%? Is it 10% for stamp and 10% for VAT?
No, they discontinued the VAT. It's just straight 10% for property now.
Yeah, but they have the 10% under VAT. I thought it said the opposite. Discontinue stamp and put it under VAT.
No, they did at first and then they switched it back.
Oh, when they switch it back?
Now, I don't recall, but I know they did because we purchased for a non-Bahamian.
Because the last thing that I read when I was looking at this on Sunday, they changed it. They moved it from stamp and they put it to VAT.
Right, and I see on page 23, they're talking about the value-added tax.
Yeah, because the last thing when I looked at it, it said everything is now under VAT. It's no longer under the Stamp Act.
But it is now.
Well, I need to find that amendment in law.
Yeah.
Because I surely did not see that.
Yeah.
I thought purchases over 100,000 was 10%.
Yes, it is.
Right.
It is. But what we're discussing now is whether it's under the Stamp Act or under the VAT Act.
Okay,
Because it's
I
not
got
both. Okay, so see, I have the Stamp Act Amendment 2000 and I can tell you right now.
16?
18.
18?
Stamp Act 2018 says, hold on, a deletion of subsection 11 and 12. And in that deletion, it includes a deed of conveyance or assignment, 100,000 and under 2.5%, in excess of 100,000, 10%. So according to the amendment that was done in 2018, that was deleted from the first schedule. So let me look at the amendment 2019 under the Stamp Act. Let's see what they have here. Oh, that's not in this amendment. That was just a $10. I'll have to find that. So you said it moved, when they took it out of the Stamp Act, they put it under the VAT Act, and you tell me it's now back under the Stamp Act?
Yes, but we can confirm that, but I know that's what we paid under the Stamp Act.
What kind of things this is?
Ms. Archer, question.
Yes.
Where did you find this book?
Which book?
Your Stamp Act book, where'd you find that?
Stamp Act book. Stamp Act is legislation.
Where you found that?
Laws of the Bahamas.
Oh.
Laws of the Bahamas.
More reading again. Okay.
Yes. So we're gonna have to look this up for the next class. Because in 2018, it was under the Stamp Act. 2019, they removed it and put it to the VAT Act. And now she's telling me that it went back to the Stamp Act. What kind of confusion this is? I don't get it. But I know you don't pay both.
Right, right.
Right. So let's leave the Stamp Act and the VAT Act out until next week. And we'll find out exactly who's paying what.
Right.
Which entity it is, whether it's under the Stamp Act with the Treasury or whether it's the Inland Revenue under VAT.
Okay.
Okay? So the next few pages just speaks about the real estate transaction. Anyone who's an expert in the field can tell me if I made a mistake, because I went to the legislation. So I have stamp duty nil. I have to check that out. And then I have the 2.5 and the 10% under VAT. So I have to check that out. Any changes to the real estate fees? Because I checked those seem not to have changed.
6%?
Vacant, 10%, non-vacant, 6%. Has it changed?
That's correct.
Oh, okay. Attorney fees? Still 2.5%, eh?
Yeah, up to 2.5. Mm-hmm.
Up to 2.5?
Yeah, it's up to.
The attorney fees is normally 3%, but each party pays 1.5.
Okay. So attorney fees, see, going up now, 3%.
You can split that as well as the real estate agent fees as well.
Okay.
Those things are negotiable.
Mm-hmm. But attorney fees is normally 3% now.
It's up to 3%. I thought it was up to 2.5.
No, it's
Thought it was up to 2.5.
So now it's 3% up to 2.5 million.
I know these fees are negotiable, so it could be up, it could be high or low. But not exceeding what the law said. But those
I
fees are
thought it
negotiable.
could not exceed 2.5%.
But it's 2.5% for each party to the transaction, plus VAT.
Correct.
The standard thing is right.
2.5% for each party to the transaction.
I know we paid 1.5 because the total was 3 and it was
based on you
negotiated between the buyer and the seller.
It depends on the law.
It depends on the law, exactly, because my lawyer, the two firms that we deal with here at the credit union, I've gotten 1.5, depending, you build that relationship and they get in they're willing to give you a better deal.
Right, because we paid 1.5 as well.
So it's 1.5 split or 1.5
1.5
each.
No, 1.5
each.
Okay.
Right.
Parties for a total of 3.
Okay, right. Okay, 1.5 each, that's better. Okay. The Bahamas Investment Board fees, I wasn't able to check. Registration fee and permit fee. I don't know if those have changed. I was trying to find it on the government website. I couldn't find those. Real property tax?
Pleasant evening.
Nothing changed. Hello?
Ms. Gardner? Hi.
Someone was saying something. All right, real property tax. I was trying to find all the new information on their assessment, but there's not much write-up on it. On the new assessment method. It has been implemented, but they didn't say. So, owner-occupied. No changes to the rates, right? Because I got these from the government website.
Okay.
No.
Okay.
No changes.
Okay. Appraisal fees, what about that? 300 to 500.
Yeah, that haven't
That
changed.
looks standard. That looks
That's standard,
standard.
okay.
Mhm.
I got that from the thing I'm told. Now the title search, I didn't have time to check that. I don't know if it's still 350. That sounds kind of low.
It depends on the.
It depends on the person who's doing it, because
And
some
the time
persons do it
involved.
250.
Okay. 250? That sounds low.
Time, it depends, I think, on the.
Yeah, it depends on the person.
The person A.
Can someone
Okay.
please tell me which company does a title search for 250?
What's it called? CompuTitle? CompuTitle. Okay, and then recording fees is $450. Mortgages.
$450 per page.
Yeah, $450. Yeah, recording fee. Then mortgages, bank service fees vary. Any discrepancy with those numbers?
Are these fees for later class?
For what you mean?
I mean, are we reviewing them now? It's just kind of getting a consensus of what they are.
No, I'm making sure that the figures I have here, because some I was able to check and some I won't, because normally they're on the exam. So when I give it to Mr. Nottage, my section, I want us to be on one accord.
Okay, so that's what I'm saying. So these fees will be discussed in a later class.
No. If I make any changes, you will get the updated version.
Okay, so what page are we on?
25.
I was on 16. Oh, what?
Yeah, we're about to be
25?
going. Yeah, we're actually on page 20. Yeah.
27.
27, eh?
27.
27. We're on page 27.
Oh, okay.
Sorry, I had a bathroom break.
Oh, all right. And what I included in here is the exemptions from VAT.
So sorry, Ms. Acho, everything
Go ahead.
that's in here. But were there any changes? I don't mean to go back, y'all, but I just want to be sure that whatever's there in the outline. Were there any changes?
I'm gonna double check the stamp and the VAT.
Okay.
And then what I did was in the exemptions from VAT, they said notes that subject to the VAT rules, the following suppliers of real property will be exempt from VAT. So I include this in here for your information. So if you give a gift
that's
of
on,
real,
on page.
which page?
You on? 27? Okay.
Yeah, that's
thank you.
27. Yeah. So they said if you give a gift of real property that is held by the transferee for at least 7 years from the date of the transfer, where there's no change in beneficial ownership, you don't pay any VAT. Any real property transfer as
What
under
does
the
that mean?
matrimonial. What you ask?
No, what does that mean?
What this means is that what they attempted to do with VAT is they've included what you call probate and estate fees. And so they're saying all angles now. They're saying that if you have a gift of real property that was held by the person who's given it to you for the last 7 years from the date of the transfer, and there's no change in beneficial ownership, or the transferees are the transferor of the transferee's spouse or parent, you don't pay any VAT for those transfers.
Okay, gotcha. Okay.
But these are just the exemptions that they put in there. So let's look at lease. So a lease is really a contract between a landlord and a tenant. And what it does is it outlines the duration of the business, the amount, the terms, the condition, duties, responsibilities, restrictions, and the obligation of both parties. And remember what I said to you, you cannot have a lease for more than your terms of years. So a lease could be short-term and it can be long-term. So what are the essential characteristics of a valid lease? When you lease a piece of property, you must have the right to exclusive possession. Do you understand what that means? When someone say you have the right to exclusive possession. Exclusive possession, go ahead.
Sorry, would that mean that you are the only person with rights to the property?
Yes. So when you turn your key and you enter into that building, you have that exclusive right to be in that property.
Right.
A lease cannot be for an uncertain time, which we all understand, because a lease cannot be greater than the time period that's contracted.
Right.
And the third one is a lease has to be created in a proper way, which means it has to have all the formalities. So there are different types of leases. A lease could be granted for a fixed period, and the term has to be certain. A yearly tenancy is one that continues from year to year indefinitely until terminated by proper notice, even if the landlord or the tenant dies or there's an assignment of interest. Or you could have a yearly tenancy created by implication or instances. And that's normally looked at the way in which the lease is actually paid. You have monthly, weekly, and other periodic tenancies. They can be created in the same way as a yearly tenancy, whether by express or by inference. A tenancy at will is where a tenant, with the consent of the landlord, occupies premises as a tenant on terms that either party can terminate the tenancy at any time. That's called tenancy at will. And normally, the tenancy is rent-free. And the landlord is entitled to some compensation for use and occupation of the premises. And then the last in this section is on commercial leases. Again, it's a contract. You have the parties, the premises, the rent, the duration, the rights, the duties, the obligation, as in any contract. So that the parties, especially the tenant, knows what they can enjoy. And of course, you know, once you enter into a leasehold and you have possession of a property, of course, you have the implied covenant of quiet enjoyment, which means that when you lease a property, the landlord should not be knocking on your door, disturbing you every minute. Because the whole point of it is that you now have a covenant of quiet enjoyment. The landlord also has an obligation not to derogate from his grant to the demised premises. And in some instances, he has ensured that certain premises are fit and proper and in good repair. The tenant has an obligation to pay rent, rates and assessments, and not to commit waste, and allow the landlord to view the demised premises to make repairs in absence of the express terms and conditions. So that doesn't mean that the landlord comes to your door every day asking you if there's something to be repaired, because then he's disturbing your quiet enjoyment. Why you saying, So for next class, we're gonna look at different types of mortgages, which should be fun. It's a short one, a short chapter. And so I will, for next class, I will give you a practice question to see if you can answer it. How does that sound?
Good.
Sounds
Okay.
good? Okay. So read up what we covered, and then I'm going to give you a practice question. I think the final exam is normally, I better not say.
Oh, not say it.
No, because they may change the format. It's normally multiple choice.
Well, could you find out and then come back and tell us? Because Miss Archer,
What you mean?
Any
I don't like multiple. I don't know. Hold on. I don't like multiple choice questions.
okay.
I don't write those. I don't write my exams with multiple choice.
Okay, that's fine.
No,
That's
she
why I say
does
let me check
not.
and see if they're doing it the same way.
Okay,
Yeah.
thank you.
Because
We'll
in my opinion, multiple choice don't really.
Doesn't really get your brain churning.
No, it doesn't. It's
Okay.
just you memorize and you tick a block, rather than knowing if you actually understand what it is that you read. So I'll see if they're doing all multiple choice or there'll be space for short answer.
You better go check those police and defense force exams then.
They only do multiple choice?
I don't know, but I'm seeing one and it looking like they got multiple choice on there, so you better go check them.
No, I don't like multiple choice at all. I like the brains to be churning. All right, so for my homework, I'll look up the stamp and the value added tax to see which one, where it landed. Like you said, you said it was in the Stamp Act, so I'll look to see if there's another amendment that's not on here. I may have to go down to the printing place and see if there's any more amendments. All right, so everybody excited? Ready for the next class?
Mhm.
All right.
So we're just gonna do module 3 next class.
Where's my schedule? Next class will be, yeah, just module 3, so it won't be long.
Okay.
And then we'll do module 4 the following week.
What? How do we skip module 2?
I've already done it.
We just did it.
Oh.
So,
Which
okay, I
break
don't
were
feel
you
bad.
on?
Even with my break, I don't feel bad.
This class will be right on Tuesdays.
Yes, just Tuesdays. You want it earlier?
No, that's fine for me.
Oh, I thought you wanted it twice a week.
I can do that too, the way you go through these modules. Because, Thanksgiving is for that in my mind. But that's fine. Okay, next week.
Yeah, but I know everybody is working, and so when you have classes twice a week, it could be kind of hard because I have a class now that's twice a week, and most of the students they lag behind. They don't have time to read. They don't have time to understand, and then it piles up on them, and they get frustrated.
Mm-hmm. Yeah, I understand. No problem. Not a problem.
Yeah. But whenever you're ready to speed it up, let us know.
So, sorry, question.
Go
So
ahead.
this is for 11 or 12 weeks?
What?
4.
11. It's 11 weeks on the schedule. The 12th is the exam.
Okay.
The 12th week is when you take the exam, which is January the 12th. You want the exam earlier? I can arrange that.
The exam is January 12th. Wow.
Yeah, you want to do it before Christmas? Even
No,
better.
'cause I'm looking at this thing that Mr. Pratt sent. It has December 8th.
For what?
The final exam.
No. You looking must be at the first schedule.
Okay, I didn't get the updated one.
Got a schedule.
Today's the 6th.
Okay.
We did 1 and 2. Then you have the 13th, the
Can we
20th.
confirm it the 6th week, main week?
What's that?
If we want the exam in December or January?
Just tell me. I will tell him.
Okay.
Me personally, I will never go over the holiday. I get it over with.
Yeah,
and
we
forget
want the
it.
exam in December.
I mean, I don't want to just jump and
Yeah, before the
and say
holiday.
conclusion
Because
now and
guess
say
what?
December, but if
After the
by the
holiday,
6th week, if we
you'll have to read all this over again.
Yep.
I know not.
I have a question.
Go ahead.
I'm in Freeport. How would the exam be given?
I know they have an invigilator. It depends on how Miguel is doing it. If he's doing it online, I think he has a way to do it online. If not, there's an individualator in Freeport that they use.
Okay, thank you.
Yeah. Yeah. So what you all want to do? Tell
Before
me.
the holiday.
Before the holiday.
Before the holiday and multiple choice.
Now listen here.
Yeah.
All that matters is that we know the information. We don't have to think deep.
You're telling me. Okay, so the 15th is a Tuesday. I'm trying to see if maybe like in the week of December, the first week in December, maybe I could suggest to Miguel if y'all could do 2 classes in a week.
I don't want to disturb anybody, right? But where is this? Where are you seeing the date? Or is it
On the schedule.
Where is that?
Where's the schedule?
I mean, the email he sent, he only got the course outline in our notes.
But I got a
Don't you?
schedule and it ain't even the right one, according to
Now, hold on. Like the people in the movies say, don't
Yes,
get
I
the
thought
difference.
this was 10 weeks. Now it's 11 and then now 12. Right?
No, it is. It's 11 weeks. The 12th week is your exam.
Thought it was 10 weeks.
Okay. Hold on. No, we don't have to get all razzle and fadazzled.
If it's 12 weeks.
Okay, hold on. What I will do is I will ask Miguel to look at the chapters again and see if there's another 2 chapters we could put together, which is shorten it more. Okay. So that's the first thing. So if I do that, we have ourselves an extra week, because I'm looking at maybe you all could take this exam. Which day of the week you like? The Tuesday? You want to take it
For
on
the
the 15th?
exam?
You want to take the exam on December the 15th?
What day is that?
That's Tuesday.
Tuesday or Thursday.
That's a Tuesday.
That's a Tuesday.
Okay.
So I could say you want to take the exam December the 15th or the 17th, which is a Thursday, Tuesday or Thursday.
Not the 17th. The 15th sounds way better.
15th. Okay, on the 15th, they want to take the final exam.
Yeah.
So all that means is that you have to merge 2 classes together, Mr. Nordich. That's all. I'll tell Miguel that you all don't want to take it in the new year. And he'll just have to make the adjustments. All right?
Thank you.
And so we'll
Thank
get back.
you.
I'll get back to you. I'll get back to you on the next class, or Miguel will just send another revised schedule out. So that sounds good, hey?
Yep.
I think so.
Yes, thank you, Ms. Archer.
Okay. All right. So I'll let Miguel know. Okay.
All right.
All right. So happy reading. I still will give you a question. It'll be multiple choice. But at least I know you'll understand. All right. Oh, and I'll also check to see. The format for the
Okay.
finals. Okay. Let's see if it's multiple choice. And I know they like to give like the chapter we just did, the percentages and things like that. I don't write exams like that because they always change. Yeah. So to me, it doesn't make any sense you memorizing that 100,000 and under is 10% and this is no. Once you understand
The concept. Yeah.
and you know where to go to look for it, that's what's important.
Correct.
Because even if you were to draft something and you go to the treasury, go to Inland Revenue and it's incorrect, they will tell you.
Yeah, that's true.
So you don't need you to keep in your mind every day that it's 10%, 10%, 10%, 10%. Because when you go, the people will tell you, say, guess what? The government amended that and amended that again and amended it again, just like we were discussing. And it was 15, it went down to 12, it's now 18.
Yeah.
And you go, what? No. It's the concept you need to understand. So I'm gonna make that point too. No figures.
You could confirm the Quarantine Act as well, because I checked it. It was 20 years and it went down to 12. So you need to check to make sure it's still 12.
Okay.
The Quarantine Act.
For
that you
quieting?
talked about. Mhm.
Yeah. No,
It
and
was
then someone
20,
asked
not
me about
12.
adverse possession too.
Okay.
Yeah, adverse possession. I have to look that one up too. So quieting went from 20 to 12, and then I have to check adverse possession. Let's see what that is now. Okay, I'll have those points for you all for next class. All right, happy reading.
Good night.
Yes, good night. I should keep you all until 9 o'clock.
So will the link be the same or
No, no, he's sending a different link next week, he said.
Okay.
Okay.
You said
all
we
right.
have a homework question?
No, I'm giving you a question when you come to class.
Oh, okay. All right.
Or I may send it before. You want me to send it before?
Yeah, please. Yeah, send it before.
Send it before.
So we can discuss it.
Yeah, send it before.
Okay. All right.
Yeah.
That's good. That's good with me. All right.
Perfect.
Make sure
Thank you.
let me see if I have everybody who's on the thing first. Don't go. I'm gonna call your name. Make sure you're here. Cleopatra.
I'm right here.
Natalie.
Yes.
Natalie.
Yes.
Jean Marie. Brianka.
Correct.
Chantel. Kenny. I didn't hear Kenny mode at all. Kimberly. Chanel.
Yeah.
Elena.
Yeah.
Magnal.
Here.
Chia. Anyone else I miss?
Owen Curry.
Hold on. Owen Curry. Who else?
Missy Russell.
Mitzi. I don't have Mitzi here. I have Mary.
Or Mary Russell. Same
Okay,
person.
all right. Who else I miss?
Lauren Russell.
Oh, Lauren. Okay. I have you now, Lauren. Anybody else?
Felia Benavy and Felisa Williams.
I don't have no Williams on here.
Robert Benavy on there.
I have Felisa.
Yeah.
Yeah, I have Felisa Benavy. Who's Williams?
No, it's Felisa Williams. Felisa Williams and Felia Benavy.
Oh, I have a Felisa Benavy and a Felia Benavy. So Felisa is a Williams.
Oh.
Yeah, Billy. Yeah,
Okay,
Benavy is.
What y'all was saying just now?
Miss Archer, that's all right. You got either one because Benavy's my maiden name.
Okay, because the email I have for Felice.
The Benavy, right? That's why.
It's the Benavy. Okay, and then Felia is just P Benavy.
Yes.
Yeah.
They're not one and the same person though.
No.
Oh, okay. So I can take off this Williams here then.
No.
What you mean no? You confusing me now.
Hey, well, add it. You can hyphenate it then, Miss Archer.
Oh, okay. So you are Benavy Williams.
Yes.
Oh, good God. Don't confuse me. Okay, so you are number 5. Okay, because I can't take you twice. Okay, good. So those, the names I have
Send it
taken.
to you in the chat.
Say that again. Repeat. Rapido.
I am.
One at a time.
Chia Gibbs, young Gibbs said her mic is not working.
Okay,
but
I
she's
have her.
participating.
Yeah, I have her. I heard her.
Okay.
Yeah, her name comes up when she speaks. See it right here from Chia.
Send it to you in the chat.
No, you're breaking up. Say it again. You typing something?
Ms. Archer, I know my name.
What's your name?
Burrows.
Burrows? Oh, Gia. No, I didn't have your name. Okay.
No, I didn't pay for this whole class up front. I got
No,
words
but
in
your
it.
name is, yeah, but your name isn't coming up. That's
Oh, it
why.
isn't?
No,
Oh, okay.
no.
Okay.
When Chia and all of those speak, their name comes up at the bottom. So I can tell exactly who's speaking.
Oh.
All right, okay. So y'all give me plenty of homework to do. Good night.
Good night.
I get more homework. I get more homework than y'all. So I'll email y'all the question
Okay.
or questions.
All right. Everybody
All
have a
right.
good night.
All right, good
Okay,
night.
bye.
Have a good night.
Okay,
Okay,
good
bye-bye.
night.
All right. See you next
Good
week.
night.
Okay, good night.
Good night.
Good night.